All right. I apologize for the delay, but we should be going live for the eviction moratorium and summary eviction overview in Nevada. My name is Ray Gertkin. I'm the directing attorney of the Reno Office of Nevada Legal Services. And today I'm joined by Ashley Cummins and David Olshan. Ashley and David, go ahead and introduce yourselves.
Hi, everyone. My name is Ashley Cummins. I'm a staff attorney in the Reno office.
And my name is David Olshan, and I'm an attorney in the Las Vegas office.
All right, so we will go ahead and get started. But first, I just want to remind everyone that the information contained in the presentation is provided for educational and informational purposes only and should not be construed as legal advice or as an offer to perform legal services on any subject matter. But we'll go ahead and get started. So just as an overview, this presentation will cover the current status of evictions in Nevada. So we'll go over the current moratoriums. We'll also talk about the summary eviction process in Nevada and give you an overview as well as specific and general defenses to various notices that you might receive during and after the moratorium is lifted. All right, but to start off, Emergency Directive 8, this is Governor Sisolak's eviction moratorium, and it says no lockout, notice to vacate, notice to pay or quit, eviction, foreclosure action, or other proceeding involving residential or commercial real estate based upon a tenant or mortgagee's default of any contractual obligations imposed by a rental agreement or mortgage may be initiated. So this is what the language of the moratorium says, and it is based on the declaration of emergency that was issued on March 12th. One thing that it carved out, though, was that the moratorium does not prohibit the eviction of persons who seriously endanger the public or other residents, engage in criminal activity, or cause significant damage to the property. So it will allow landlords to essentially issue eviction notices to tenants during the moratorium. Usually we're going to see a nuisance or lease violation notice, but that notice has to allege actions that seriously endanger the public or other residents, engage in criminal activity, or show that you are causing significant damage to the property. The one thing the moratorium did make clear, though, is that having coronavirus or being exposed to coronavirus does not serve as the basis for establishing that a tenant or resident seriously endangers the safety of others. So what does this essentially mean in terms of the moratorium? It means that landlords cannot and should not change the locks or issue eviction notices to tenants, either putting them on the door, putting them in the mailbox, doing anything to scare them or force them to move out. The moratorium prevents essentially all evictions except for that exception that we mentioned. It also applies to residents of extended stay motels and weekly rentals. Generally speaking, residents in weekly rentals or extended stay motels are tenants. The only time that a weekly resident is not a tenant is if they do not intend to remain for 30 days or longer. So essentially, people who are living in extended stay motels or weekly rentals do qualify as tenants, and this does apply to them. This does not mean, though, that rent is free. There is no free rent. Tenants are still obligated to pay rent, and the moratorium, the Directive 8, does encourage landlords and tenants to work together to come up with a payment plan for paying the back rent once the moratorium lifts. Lease agreements are still in effect. So landlords and tenants must still adhere to the terms of the lease, and the rent is still due for the time you occupy the property, and landlords are also obligated to continue providing maintenance and other required services. The moratorium also, though, said that no late fees can be charged if someone can't pay rent due to the moratorium or COVID-related reasons. Again, the directive applies to all evictions, including those already filed in courts. So it does essentially operate to stay any evictions that were filed in court or do get filed until the moratorium lifts. Again, unless the and I apologize, that should be initiated due to the tenant posing some non-coronavirus related danger to the other tenants, the public, criminal activity, or property damage, the exception that we talked about. All right, I'm going to turn this over. Ashley, you want to take us through the CARES Act?
Sure. So the CARES Act was a federal legislation that included some protections for tenants in certain properties. So part of the CARES Act prohibits landlords of certain covered dwellings from initiating eviction proceedings or charging fees, penalties, or other charges against a tenant for the non-payment of rent. So of course, the $1 million question here is, what are covered dwellings? Covered dwellings are rental units and properties that participate in federal assistance programs, are subject to a federally backed mortgage loan, or are subject to a federally backed multifamily mortgage loan. So generally speaking, what we're talking about when we talk about covered dwellings, the most common ones we'll probably see are most rental assistance and housing grants programs that include public housing, housing choice vouchers, Section 8 project-based rental assistance, rural housing programs, low income housing tax credit units. Additionally, covered dwellings include federally backed mortgage loans, so single family 1 to 4 unit residential mortgages that are owned or secured by Fannie Mae or Freddie Mac, or insured, guaranteed, or otherwise assisted by the federal government would also be considered a covered dwelling. So what the CARES Act does is it prohibits landlords of certain covered dwellings from initiating the eviction proceedings or charging, like we said, fees, penalties, or any other charges against a tenant for non-payment of rent. So what is prohibited? Landlords that receive some sort of federal funding cannot evict tenants for non-payment of rent. They also cannot charge late fees or other penalties due to non-payment. This extends for 120 days, so from March 27th to July 25th. Now, after that ends on July 25th, landlord is required to give a 30-day notice to the tenant before the tenant must, essentially before initiating any sort of proceedings to force the tenant to vacate the unit. So basically you would get another 30 days after July 25th. So what can you do during this time period while we're under the moratorium? If you cannot pay rent, we do strongly suggest that you attempt to work out some sort of payment plan with your landlord. If you do enter into a separate agreement regarding payment of rent, make sure you have that in writing and that back rent owed is properly calculated. So double check the math, get that in writing, and make sure you keep a copy of it. If you receive an eviction notice or your landlord is threatening to evict you while Directive 8 applies, do not voluntarily vacate. You can file a complaint with the Attorney General's office online or over the phone and essentially notify them that your landlord is violating Directive 8. If you receive an eviction notice that alleges you endanger the public or other residents or have engaged in criminal activity or caused significant damage to the property, we recommend that you contact our office and be prepared to file a tenant's affidavit, which we'll talk about later in this presentation. If your landlord locks you out, contact our office right away. You may be able to file what's called a verified complaint for illegal lockout or a motion to set aside, depending on your circumstances. So we'll talk a little bit about summary eviction. So in Nevada, self-help evictions are not allowed. So what that means is that landlords have to go through a court process where the court orders the sheriff or constable to evict. Landlords are required to serve you with proper notices and then wait the required period of time before they can ask the court for a lockout order. So the general steps to summary eviction in Nevada is that the landlord's going to serve the tenant with a proper notice or notices. Tenant then should file a tenant's affidavit alleging a defense with the justice court. Landlord will then file what's called a landlord's affidavit asking the court for a lockout order, and a hearing will be held to determine if the eviction should move forward. Either the case is dismissed or a lockout order is issued after the hearing. And if a lockout order is issued, the tenant will be locked out 24 to 48 hours after that order is posted. It is so important. The one thing to take away from today is that if you do not file a tenant's affidavit, you will be locked out without a hearing. No hearing is scheduled unless the tenant files a tenant's affidavit. So with the steps above, if you don't file a tenant's affidavit, the landlord can go to the court with the notices that they served you and file their landlord's affidavit and get that order to lock you out without any sort of hearing, and you would only get the 24 to 48 hours notice. So just remember, file that tenant's affidavit. So some of the types of notices that we see when we talk about, oh, well, landlord's going to have to serve the tenant with proper notices would be a 7-day pay rent or quit notice. For this notice, no other notice is required. The landlord only has to give the 7-day pay rent or quit notice. There's also a 5-day lease violation notice, which must be followed by a 5-day unlawful detainer notice, a 3-day nuisance notice, which must also be followed by the 5-day unlawful detainer notice, and then a 7 or 30-day no cause notice, which also must be followed by a 5-day unlawful detainer notice. The notices have to be served properly. So they have to be served by a sheriff, constable, licensed process server, or an agent of an attorney. And the notice must either be delivered to the tenant personally, as in handed to you, or if the tenant is absent from the place of residence, by leaving a copy with the person with suitable age and discretion and mailing a copy to the tenant. Or what we usually see is the notice has to be posted in a conspicuous place on the leased property, and then a copy must be mailed to the tenant. So some moratorium specific defenses that you could raise for an eviction that's happening while we are still under Directive 8. So obviously the main one is Directive 8 prohibits the eviction, right? The notice does not allege serious circumstances, enough serious circumstances to allow the eviction to happen under Directive 8, meaning they're not saying that you're a threat to others or have damaged the property. The allegations do not seriously endanger public or other residents, and you have not, doesn't show that you engaged in criminal activity, and also does not include any allegations of significant cause of damage to the property. So essentially the landlord has to prove that they fit this exception to continue with the eviction, and you're going to say, hey, they don't. Or you can argue that the CARES Act prohibits the eviction. So landlord is federally backed. So it's one of those covered properties like we discussed. Now, another interesting note is the way that the law was written is it might give you some wiggle room to argue that the CARES Act prohibits landlords for being able to force a tenant to vacate a covered dwelling for non-payment of rent or any other reason until August 23rd, 2020, which is 120 days after enactment, plus then the additional 30 days after you receive the notice. After the moratorium is lifted, you can say the notice to vacate or unlawful detainer notice issued during the period of moratorium was in violation of the CARES Act or Directive 8. What that means is if your landlord does give you an eviction notice during this period of time, and then tries to give you a second notice, the unlawful detainer, after the moratorium is lifted, it's trying to say, oh yeah, I already served you with the first notice. You can argue that that first notice was improper because it was served while the eviction moratorium was in place.
So basically with the moratorium, what we're saying is essentially, I just want to, clarify, if you get an eviction notice during the moratorium that does not allege the serious endangerment of the public, that you engaged in criminal activity, or that you caused significant damage to the property, your landlord should not be able to go to court to get a lockout order. That is what the moratorium says. And in simply issuing you that eviction notice, the landlord has violated the order or the governor's directive. So you can file a complaint with the Attorney General's office, and the Attorney General will contact your landlord. So what we're saying when we're talking about raising a defense is if you get a nuisance notice or a lease violation notice during this time period. So just to clarify, the CARES Act does really only apply to non-payment of rent. So the CARES Act does not stop your landlord from alleging that you violated the lease or were a nuisance. There is some language that makes it unclear, whether or not the landlord can issue the eviction notice in that 30-day time frame. But do remember that the CARES Act really only relates to non-payment of rent. So if you're getting a notice that you are a nuisance or violated the lease, what we're talking about in terms of a legal defense is that the allegations are not sufficiently serious enough to say that you should be locked out during the moratorium. But this is going to require you to file a tenant's affidavit if you get a nuisance or a lease violation notice. Okay. If you get a non-payment of rent notice, though, you technically you should not have to do anything essentially, because the court should not accept the filing, and the Attorney General's office, if you file the complaint, will contact your landlord and let them know they're violating the moratorium. Not that you needed clarification, but if so, hopefully that helps.
Yes, and we do have, I see a question on the YouTube channel. Ray, do we want to answer questions as we go, or should we wait for
I
the?
think that's a good idea.
Okay.
We can take a pause and answer questions as they come up.
So we do have a question that is, if a landlord decides to sell the home and gives a 30-day notice, are there any restrictions to this situation?
The answer would be yes, and David can help clarify this, but essentially the moratorium means moratorium. There should be no cause evictions while the moratorium is in place.
That's exactly right. And they can't show the house during the moratorium, and they can't prepare the house for the sale. The tenant gets to live there in peace during the moratorium. And it goes back to your argument, Ray. If they do issue this notice during the moratorium, you can argue that it's invalid and they have to issue another notice. So there you go.
Right. And, there is a question that we're going to talk about later, of course, what happens when the moratorium lifts. But essentially, if the moratorium lifts after the 30 days have expired, I think there's going to be an issue of whether or not the landlord should have to issue a new notice or not. I think the answer is yes, but that might be a contentious issue later on. But we'll go ahead and keep moving forward. So I'll go through the general defenses to summary eviction. So in addition to the moratorium defenses that we just talked about, you still also have regular summary eviction defenses, and these are mostly going to apply after the moratorium lifts. But essentially, we're arguing that the court doesn't have jurisdiction to enter an eviction if the unlawful detainer notice was served before the first notice expired. And we're always arguing that the notice does not properly advise the tenant of his or her right to file a tenant's affidavit or other statutorily required language. NRS chapter 40.253 governs summary eviction process in Nevada. And it's really important that landlords follow the statutory requirements. If they don't, the notice is defective, and the tenant can properly raise a legal defense that the notice is defective. And then also the parties have to be named as landlord has to actually be the landlord. So you have to be the owner of the property or an agent of the owner of the property. And then if you weren't served properly, that's another general defense that you can raise to any summary eviction action. But now we're going to go through a couple of the notices that you might receive and talk a little bit about the defenses to those notices.
And we have 2 questions that just came in.
Okay.
One is, I have a leaseholder that has turned in keys, but he let an unauthorized person to stay there, and that person doesn't want to turn in the keys. What can I do to remove the unauthorized tenant? I don't have her info.
David?
Yes, we got a similar call yesterday, and that is a housebreaker. It is one of the exceptions because it is criminal activity, and you can go forward with the eviction if you want to. The notices, there's a 4-day notice, and that's all that you have to serve. It's a sort of a hybrid procedure, and yeah, that's how you take care of the problem.
And the second question is also, if a tenant is on a month-to-month, can you give 30 days notice? Based on what you were saying, the answer is no. Is that correct?
Yes, that is correct.
For the period that the moratorium's in.
Yes. Right now, while the moratorium is in effect, there you cannot give any eviction notice, except like we were talking about with the exception, if there's a serious threat.
Okay, that's all the questions for now.
And another notice that you should not be issuing, or landlords should not be issuing to tenants right now, is the pay rent or quit notice. But once the moratorium lifts, obviously, we believe that this is going to be a significant issue. The moratorium does encourage landlords and tenants to work out payment plans right now to try to allow tenants to remain and pay the back rent that is owed. And so that is encouraged, but there is nothing specifically saying what happens once the moratorium is lifted. So if a tenant does get a 7-day pay rent or quit notice, remember that is the only notice. Once you get that 7-day pay rent or quit, the tenant has to take action to stop the eviction. But the notice itself must state the amount of rent owed, have the proper parties listed as we discussed, advise the tenant of his or her right to contest the notice by filing the tenant's affidavit, include language that informs the tenant of his or her right to seek relief if the landlord unlawfully removes the tenant from the premises. So 118A protects against unlawful and illegal lockouts. The notice has to advise the tenant that there is a way to seek relief if the landlord does illegally lock the tenant out or interrupt an essential service. And the notice has to advise the tenant that if a court determines the tenant is guilty of an unlawful detainer, the court may issue a summary order directing a sheriff or constable to remove the tenant 24 to 48 hours after receipt of the order. The tenant then has 7 judicial days from the date of service of that notice to file a tenant's affidavit if the tenant wishes to contest the eviction. The landlord may receive a lockout order without a hearing if the tenant fails to file a tenant's affidavit on time. So remember, tenants have to file if they want to stop the eviction, because they will get evicted without any further notice if they don't. So what are potential defenses to a pay rent or quit notice? 1, if the tenant paid the rent, clearly that's a defense. If the landlord and tenant entered into a separate agreement for the amount owed and the tenant has not violated that agreement, could be a possible defense. That the landlord refused to accept payment of rent. The tenant properly withheld rent if there was a habitability or essential services violation pursuant to NRS Chapter 118A. The amount on the notice is incorrect or includes amounts that are not rent or improper late fees. And just remember, during this moratorium, landlords are not allowed to charge late fees. So even after the moratorium lifts, the landlord cannot recapture the late fees that they could not have charged during this moratorium. The rent is still owed, but the late fees are not.
We have a question about rent. The question is, can my landlord threaten to raise my rent if I don't sign another lease right away? We are in between lease agreements.
So there's no prohibition on increasing rent in the moratorium. So as long as all other laws are followed regarding increases in rent, there is nothing prohibiting it.
Well, right, but they have to issue a
45 days notice.
45-day notice.
Yeah. So just under chapter, that's 118A, right? Yeah, I think it's 118A, but generally speaking, for landlords to raise rent, they have to provide 45 days written notice to tenants.
And of course, your lease has to expire. They can't do that during the term of the lease.
Right.
And then the second question, I think it's a question, it just says the 4-day notice must be delivered by the process, or can it be by management and sent by mail? So I think it's asking about service of notices.
And no, management can't serve eviction notices.
Correct.
Okay, that's it. That's all the questions for now.
All right. All right, so we're going to talk about lease violation notices. So chapter 40 requires a 5-day lease violation notice if a tenant is violating a lease. In order to move forward with a summary eviction, the landlord then has to issue the tenant a 5-day unlawful detainer notice, which essentially says you did not do what you were supposed to do after I told you you were violating the lease and now I want to evict you. That 5-day lease violation notice must describe the lease violation, and the 5-day unlawful detainer notice must state the proper court and parties, advise the tenant of his or her right to contest the notice by filing the tenant's affidavit, inform the tenant of his or her right to seek relief if the landlord unlawfully removes them from the premises, advise the tenant if a court determines the tenant is guilty of an unlawful detainer, the court may issue a summary order directing the sheriff or constable to remove them 24 to 48 hours after the lockout order is issued, and advise the tenant of his or her right to request a stay of eviction. So with a lease violation notice or a nuisance notice, the tenant can ask for a 10-day stay of eviction pursuant to NRS 70.010, and the notice has to advise the tenant of the right to request a stay. So the tenant then has 5 judicial days from the date the unlawful detainer is served to contest the eviction by filing the tenant's affidavit. Some of the defenses, again, the lease violation notice has to advise the tenant what they did to violate the lease. So 1, the tenant has a right to cure the lease violation. If the tenant cures the lease violation, then they have a defense to the eviction. If the violation isn't a material provision of the lease, the tenant can raise a defense that eviction is a harsh remedy for something that is an immaterial violation of the lease. Or that the tenant didn't actually violate the lease. So the tenant denies that the lease violation actually happened, or that the actions alleged are not actually a violation of the lease.
And we have a follow-up question, it looks like, to the rent increase. If the question is, if you are not in a current lease agreement and you are month to month, isn't a 30-day notice for change in terms? Or isn't it a 30-day notice for change in terms?
No,
If we're talking about non-payment of rent, no. Yeah. I mean, sorry, increase in rent. David, you were talking.
that was the exact answer.
Yeah.
So
No,
an increase in rent requires 45-day notice.
pursuant to NRS chapter 118A.
Thank you.
All right. So another notice that you might be issued if you're a tenant is a nuisance notice. So a nuisance notice is a 3-day notice. Sorry, it says lease violation, but that should say nuisance. But the 3-day nuisance notice also has to be filed by a 5-day unlawful detainer notice. The 3-day notice should allege how the tenant is being a nuisance. So again, it has to contain those specific allegations of what the tenant is doing that violates the law. And nuisance is actually defined by statute, and we'll get to that definition here in a minute. But the 5-day unlawful detainer notice has to contain all of the same information that the 5-day unlawful detainer notice has to contain. And then the tenant then has to file the defense in the 5-day judicial day period of the unlawful detainer notice. So the defenses to a nuisance are the tenant is essentially not a nuisance. So what is a nuisance? Under Chapter 40, a nuisance is conduct or an ongoing condition which constitutes an unreasonable obstruction to the free use of property and causes injury or damage to other tenants or occupants of that property or adjacent buildings or structures. So a nuisance is not just, I don't like the tenant, I want them out. A nuisance is conduct or an ongoing condition. So it's got to be essentially something that is really causing a lot of damage to the property, or it's happening often and the tenant is just not doing anything about it. Again, the nuisance, the tenant can abate a nuisance. And what does that mean? Essentially, it means that a tenant can cure the nuisance. So if the argument is the tenant is having allowed parties late at night, the tenant is advised that they can't do that anymore, and the tenant stops doing that, the tenant has abated the nuisance. And again, if the tenant does not believe that the actions as the landlord has expressed in the notice actually even happened, the tenant can deny the allegations in the notice.
We have one final, or I guess not final, but another circle back question regarding the rent increase. They want clarification to know if that applies even if tenant is not in a current lease.
Well, yes, because if a tenant is in a lease, then the rent can't be increased. But if a tenant is not in a current lease, then it's a 45-day notice.
Thank
Right. And that's NRS 118A 300. I just checked.
Okay, thank you.
you. Thank you, David.
Sure.
All right, and finally, no cause notices. As we expressed earlier, no cause notices are not allowed right now during the moratorium, but once the moratorium lifts, obviously that changes everything, unless something else happens that we don't know yet. But essentially, you know, a 30-day no cause notice is a pretty standard notice that if you're not in a lease agreement, you can get to from a landlord telling you to move out. Again, in order to follow through with the eviction, the landlord has to issue the 5-day unlawful detainer notice. One of the things, though, about no cause notices is no cause notices must advise the tenant of his or her right to request additional time to move due to age or disability. So if a tenant is in a month to month, let's say the lease expired, they're continuing month to month, the tenant, if they are over 60 or disabled, can request an additional 30 days to move. Again, the 5-day unlawful detainer notice must contain that specifically required information. And the tenant has to contest the eviction within that 5 judicial day timeframe. What are defenses to a no cause notice? Essentially, if the lease hasn't expired, Obviously, you can't do a no cause notice if you're in a lease agreement. That has to be for cause. And then the really only other defenses are that the notice didn't contain the language about the right to request the additional 30 days, or the landlord refused to provide the additional 30 days. If the landlord is retaliating or discriminating against the tenant for the prohibited acts under 118A 500, or if the tenant is in subsidized housing. So if your landlord is subsidized by HUD, essentially, you have, or if you're in a low income tax credit property, essentially the lease never ends. You have a right to occupy that unit. And so you always have to get a for cause notice.
And we just had a follow-up question, Ray, I think you already touched on it, about whether or not a landlord can serve a 30-day notice to a month-to-month tenant at this time. And of course, the answer is no, you cannot while the moratorium is in place.
So what is going to happen after the moratorium lifts? So if you're in federally assisted housing, the CARES Act still applies. So the CARES Act applies until July, because it's 120 days from the date of enactment, which was in March 27th. So if you're in federally subsidized housing, or if your landlord is federally backed, meaning we talked about, you know, if the landlord has a loan that is a federally backed loan, or somehow is in federally backed housing, then the moratorium is still in effect, which prohibits pay rent or quit notices during that time, that 120-day time period. And then you're required to provide 30 days notice after that. So right now, most of the courts have issued administrative orders of various degrees saying what is currently happening. All of those orders are currently requiring judges to review them essentially every 30 days, although it could happen sooner. The courts could issue additional administrative orders once Directive 8 is lifted, but they might not. So it really depends on what the courts are going to do, possibly individually, with respect to what happens in the court system once the moratorium lifts. But generally speaking, as far as we know, once the moratorium lifts, if nothing else is put in its place, everything will go back to normal, essentially, except if you're in federally backed housing. Landlords would be able to pursue evictions pursuant to Chapter 40 and Chapter 118A.
And we have a couple questions. So the first question is, can my landlord force me to sign a lease since we are in between leases if we are between leases, or can I have a month to month during COVID?
Well, that has nothing to do with the moratorium, I guess I would say. The landlord cannot evict you, right? So if you refuse to sign a lease agreement, the landlord has to wait for the moratorium to lift to do anything. But that's completely up to you and the tenant and the landlord in terms of how they're going to operate during this time period. Because if, you know, yes, essentially you would be on a month to month essentially until the moratorium lifts, if the landlord would want at that point in time to issue you a 30-day no cause notice.
And the second question is, earlier in this video, you stated that a landlord could not give a 30-day notice if he wants to sell. Just now you said if they are month to month, they can do a 30-day notice. A little confusing.
Right. So right now the moratorium says no evictions. Once the moratorium lifts, then the landlord can give whatever notice they want.
And that's all the questions we have now. But you guys, if you have any questions, feel free to type them in, and obviously we'll get to them when we can.
But that's it. Yep, definitely let us know if you have any other questions. David and Ashley too, if you guys have any other final thoughts regarding the moratorium or evictions in Nevada. But that does it. If you would like to see if you qualify for further assistance, please feel free to call any of our local offices and we can see if there's anything more we can do to help. And certainly if tenants get eviction notices at this time and you want further information about your rights and what to do, please feel free to give us a call.
Right. First of all, we're going to be doing more of these. So we have like 34 views right now, and we will be doing more of these. And if people want a specific area, a specific legal area, they might want to suggest it to us, and we can do an Ask a Lawyer. We could cover that area as well.
Yes, that's a great idea. We got a few people saying thank you for our help. We are happy to be here to provide assistance. And like David just said, if you guys have any areas of law that you have questions on, feel free to reach out to us and we can see if it's something that we can either assist you with or put together one of these presentations on. We have a question. What can we do if tenant doesn't want to pay rent? They are refusing to pay rent.
So again, as we said, during the moratorium, rent is still owed. Now you cannot evict the tenant for not paying, but the rent is still technically owed. So once the moratorium lifts, there's nothing prohibiting a notice at that point in time, as long as a landlord, you are not federally backed. If you are federally backed, meaning you have a Fannie or Freddie loan or other federally subsidized mortgage, then you might not be able to issue a pay rent or quit notice until 30 day, essentially July 25th, you'd have to issue a 30-day notice. So, the tenant the moratorium is in place because we understand with everything happening with coronavirus, it's very difficult if people have lost their jobs. Some people still have not gotten unemployment benefits. The Paycheck Protection Program, the PPP program, not many businesses in Nevada were recipients of that program. So there's a lot going on right now that prohibits tenants from being able to pay rent. So that's why the moratorium is in place. And right now, the only thing you can do is try to work something out with the tenant if they would like to stay long-term to try to pay back that rent. But essentially rent is still owed, but you cannot evict the tenant for that at this point in time.
I believe that's it, right?
Yep, no other questions are coming in, but if anything comes up, don't hesitate to give our office a call and we can see if we can provide assistance.
But thank you everyone for attending. Thank you, Ashley and David. We'll go ahead and end the live stream. And check us out again next Tuesday. We'll actually be doing one on foreclosures. So again, as David said, give us any suggestions you have for further educational presentations. But thank you all for attending and have a good rest of your day.